I'm going to continue debunking this claim until people stop making it. Folks will still say that the Second Amendment should only apply to muskets because that's somehow all the Founding Fathers could have possibly imagined at the time of the ratification. Which is really stupid because at the time of the ratification of the Second Amendment, there existed firearms such as the Puckle gun, patented in 1718, the world's first Gatling gun. There was also the Kaufhof repeater, which was capable of firing between 30 and 60 rounds a minute. Some could even fire 29 rounds without reloading, similar to the modern-day AR-15. Similarly, you had the Belton flintlock. And in a somewhat funny design, you have the pepper box revolvers that could shoot a tremendous number of bullets with one pull of the trigger. And did they just forget that they had cannons at the time? Which, by the way, if you read the letters of marque and reprisal, the Founding Fathers were 100% in support of individuals owning cannons, and in fact said you can outfit your private vessel to become a battleship. Don't flex your historical ignorance.
Delaware's assault weapons ban is heating up in the courts, but we're hearing the same played rhetoric. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, the NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box. And if you like my channel, like my content and what I do here, you can support me with the link in the description box. Everything is appreciated. But let's talk about this. Now, in June 30th, the governor of Delaware signed into law an assault weapons ban. This is literally a week after the Supreme Court Bruen decision. And, of course, it was challenged immediately in the courts. Now, it is in the Third Circuit. Excuse me. It's in the Third Circuit Court. And I've read through a briefing here from, this is a really good website. This is called Reason. But they have a really good breakdown on what's happening in Delaware and this court case. And I'm hearing the same rhetoric. The AR-15s are dangerous and unusual. The PIST script makes it more lethal, so forth and so on. But I want to bring you into it so we can take that together. But here it is here. Now, I'm not going to read the whole thing. There's a lot here. And once again, I'll try to leave it in the description box so you can read it at your own leisure. But there's a lot here. But there's definitely some things we can touch on. But on June 30th, 2022, just a week after the Supreme Court decided the Bruen case, Delaware Governor John Carney signed into law a ban on assault weapons and standard capacity magazines effective immediately. Apparently, he didn't get the memo that a ban on firearms in common use is off the table constitutionally. And as you see as we go into this article, you're going to see the court try to do a little real serious mental gymnastics to get around that common use ideal. But okay, Delaware plagiarized California's 1989 findings that it was imperative to ban any gun that is not a sports or recreational firearm. That's how California pushed theirs through. The state ignored the Delaware Bill of Rights guarantee of the right to bear arms for the defense of self, family, home, and state, and disregarded Heller's admonition that self-defense is the central component of the right itself. Delaware copied the definition from Connecticut that criminalizes a firearm depending on where one's fingers are placed when firing. That was the big support for SB 1160, that language. You know, how your fingers actually set themselves around the firearm. They had this whole definition that was insane. And Maryland's long list of banned items, rifles such as Colt AR-15, curiously, that list excludes AR-15 H-bar unless made by Bushmaster. Any semi-automatic rifle made by that firm is banned. But the U.S. District Court for the District of Delaware denied a motion by challengers for a preliminary injunction on the basis that they are not likely to prevail on the merits, which is interesting, seeing that Bruen is already in play. How can the court say, the plaintiffs are not really going to win this case when you've got Bruen clearly saying, if it wasn't banned then, you can't ban it now. But the case is Delaware State Sportsmen's Association versus Delaware Department of Safety and Homeland Security. Appeal briefs are now being filed, which includes an amicus curiae brief on behalf of the Delaware Association of Second Amendment Lawyers by yours truly and co-counsel Dan Peterson. here are some of our arguments. So that's very interesting. I did not know that the attorney who's involved in this case wrote this article and he's breaking it down. But Heller held that arms that are in common use for lawful purposes, those chosen by the American people, are protected by the Second Amendment. And everybody knows that the AR-15 is the most popular rifle in the country. That rule should resolve any gun ban without further ado, you would think. Bruen's methodology, which evaluates restrictions by reference to the text of the Second Amendment and historical analogies, applies to regulations such as about where guns may be carried, not to outright ban on possession where common use test applies. Now, here's where the mental gymnastics come in. This is the Third District Court agreed that rifles like the AR-15 are in common use, which should have conclusively supported a preliminary injunction. Instead, the court reverted to means and scrutiny, which Bruen flatly rejected. The court found such rifles to be exceptionally dangerous, because an AR-15 is more dangerous than an M1 Garand or a Mini 14 or an M1 carbine. It's insanity, but which it substituted for the Supreme Court's test of dangerous and unusual. But it did not explain why the ban features makes the rifles so dangerous. It claimed that pistol grips and barrel shrouds supposedly increased their lethality, but offered no clue why. You know why they didn't offer a clue? Because they know they're full of it. They know it. They're not going to offer it. Let's see how we can stall this. Let's find any language you can to stall this thing. That's what this is about right here. Because what they just said is absolutely idiotic. The AR-15 is more exceptionally dangerous than any other rifle. Okay, but consider the verboten feature of a semi-automatic rifle with a grip that allows a finger, in addition to the trigger finger, to be below the action when firing. That was SB 1160. Those of us in Connecticut kind of question that language a lot, but that's what they used to pass the first assault weapons ban. Well, SB 1160 here. Are we to believe that a rifle is more lethal if one's fingers are in this position rather than in some other position when firing? The very idea that one's finger's placement removes an arm from Second Amendment protection trivializes the constitutional right. Okay, now, I'm going to come down to here. This is another one of those mental gymnastic moments. The court claimed that an assault rifle bullet travels at multiple times the velocity of a handgun bullet. FN 57? But there's no such thing as an assault rifle bullet. Bullets such as .223 caliber may be fired from any rifle of that caliber regardless of the rifle's features. The relatively low power .223 is not even allowed for deer hunting in Delaware and a number of other states. Yes, you must have a .30 caliber or bigger to hunt deer because they consider anything smaller than that inhumane. But the court identified rate of fire as another dangerous characteristic, but a semi-automatic rifle with, example, a pistol grip fires no faster than a semi-automatic rifle without one. Standard Mini 14, AR-15 is the same thing. But once again, this is not about logic. This is about stalling this thing for as long as they can. Delaware does not ban semi-automatic rifles without the outlawed features. Now, this is where it gets interesting, and I'm going to jump down after I read this section here, but the district court placed great weight on what it considered to be historical analogies to justify the ban. But the claimed analogy turned out to be the restrictions in a minority of antebellum states on the concealed carry of pistols, bowie knives, clubs, and the like. These laws were upheld because open carry was allowed, so they cannot be precedents for a ban on mere possession of an arm today. Early laws went too far, such as Georgia's 1837 ban on carrying a pistol openly or concealed. They were invalidated. The Georgia Supreme Court in Nunn versus State declared that prohibition violative of the Second Amendment. Heller approvingly cited Nunn when it commented, "Few laws in the history of our nation have come close to the severe restrictions of the district's handgun ban, and some of those few have been struck down." And this is where it gets into the history. And this, I want to get this here and then we're going to come out. But there is a historical twin, though, to Delaware's ban on mere possession. The ban on possession of arms by slaves and free persons of color in the antebellum South. That ban was defended on grounds that African Americans were not citizens and had no right to keep and bear arms. Delaware's ban is exactly what the Second and 14th Amendments were understood to prohibit. Delaware punished with whipping any Negro or mulatto slave who would carry any gun, pistol, sword, dirk, or unusual or dangerous weapon, and forbade free Negroes and free mulattoes to have, own, keep, or possess any gun, pistol, pistol, sword, or any warlike instrument, except that a discretionary permit could be issued to possess a gun or fouling peace. Delaware's Court of General Sessions justified the ban applicable to free blacks on the police power. Now, I've done several stories and videos back and forth on this, considering literally the foundation of gun control. Gun control was founded in racism. So when you hear Joe Biden say, when the Second Amendment was written, not everyone was allowed to own a gun, he's right. And it was based on racism. That's where gun control got its start. Okay? After slavery was abolished, the black codes replaced the slave codes. Mississippi prohibited a free man from having a firearm, bowie knife, or any other weapon without a license. This was the first state law noted by the Supreme Court in McDonald v. Chicago as typical of what the 14th Amendment was meant to prohibit. Now, okay, I got pretty much really what I wanted to touch on in this guy's article. Like I said, it's pretty long. I don't want to spend my time half an hour just reading this. But let's come up. So, Delaware, the Third Circuit, is obviously just using some very aloof language to just have a reason to hold this case down, to hold it back. So it has to go to the next level through appeals. They don't want to give any ammunition, no pun intended, to support the ban being overturned, to move it to the next level. Because their wording exceptionally dangerous, and their whole foray into pistol grips, which is in the Delaware law, where your fingers lay when you put your hand around a pistol grip, if it's underneath the action of the weapon, is all nonsense. We know this. But I found this article very, very interesting. As I said, it's one of the lawyers who's involved in the case, and he breaks it down really well. And it looks like they're going to take this into court and argue it from the position of the establishment of the 14th Amendment, where blacks and free slaves, mulattoes, were not allowed to own firearms. And they're going to take that, basically that approach to saying that what Delaware has done is a complete violation of not only the Second Amendment, but it seems to be a violation of the 14th Amendment. And I think it's fascinating. It's a good angle to come from, quite honestly. But this is, once again, another step in numerous cases across the country that's going through the courts right now. And we kind of got to keep up with all, because one case affects all the cases. And I'm waiting with bated breath for the first case to hit the Supreme Court, specifically challenging an assault weapons ban in the state, wherever the state that brings it up first. And hopefully that will, I was hoping this year, possible, but probably next year. But great article. I'm going to try to leave it in the description box. You should definitely look through it, because like I said, this is a lawyer, and he does a very good job of basically bringing this thing into focus. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.